and welcome to FirstService Residential's Florida's new executive order and what it means to you. As you probably know, Governor DeSantis recently issued an executive order about changes in local COVID-19 emergency orders and related public health restrictions, and these will directly impact Florida condominium and community association board members. Today, we will be sharing insights and answers to your most pressing questions as we help you navigate this next phase of the coronavirus pandemic. We've assembled a great panel of respective experts to discuss and define the implications of the executive order and its potential impact on the community associations. My name is Chris Wenger. I'm a director here at FirstService Residential, and I'm happy to be moderating today's webinar along with our esteemed panelists. Joining us today are Kim Pinillos, Vice President, South Florida High Rise for FirstService Residential. Welcome, Kim.
Thank you, Chris.
We have Kenneth S., Director, and I'll refer to him as Ken throughout the webinar today. He's a shareholder, board certified specialist, condominium and plan development law from Becker. Thanks, Ken, for joining us.
Thank you, Chris. And the only people who call me Kenneth are people who are mad about something. So Ken is fine.
Amazing. So welcome, Kim and Ken. We're thrilled to have you, and thank you for sharing your insights today. So we'll get right into the first questions. Effective May 3rd, 2021, Governor DeSantis, by way of Executive Order 21-102, suspended all remaining local government mandates and restrictions based on the COVID-19 state of emergency. This order provides that all local government COVID-19 restriction and mandates on individuals and businesses are hereby suspended. However, this order does not address private rules enacted by Florida's community associations. So Ken, I'll look to you for some of this advice. Can you expand on this for us? What does this mean and how does this impact condominium and community associations?
Well, this order is consistent with the governor's preference to see businesses reopen. And that's been the governor's preference for many, many months. This order suspends, and the soon to come legislation that is consistent with this order will suspend the right of individual counties and cities to adopt their own COVID restrictions, which frankly has made some sense because the level of the pandemic has varied from county to county. But this still prevents counties from having different restrictions and cities from having different restrictions. I do not believe this provision, by the way, this also precludes them from adopting new restrictions during the COVID crisis. I do not believe this applies to community associations, which still have the right, and I would say the obligation, to take reasonable steps, a good faith effort, which we'll discuss later, to make sure that they have protocols in place to protect the people who live there and the people who work there.
Okay. Kim, did you want to add anything in terms of how this is affecting your communities?
Well, I think for us, between now and the expiration of the emergency order, the state of emergency, the associations can continue to enforce mask and social distancing protocols and the rules that they enacted under the Emergency Powers Act. So I think that's the real impact for the associations at this point.
Yeah. So going on to another bill that was recently passed was the first, we understand as FirstService Residential that SB 2006 is of critical importance for community associations, particularly pertaining to rules and documents. So just as a reminder, this bill relates to the vaccine passports. So Ken, can you summarize the Senate Bill 2006 and what that means, the emergency management efforts of our community association?
Well, there are a lot of governmental machinations associated with emergency orders that are addressed in this bill, but the one that is most pertinent for us is that you cannot mandate a vaccine passport. Now, this means you can't mandate a vaccine passport to come in to a business, to come into a restaurant, to come into your community, arguably. It doesn't mean, as Kim just correctly pointed out, that you can't still impose certain safety protocols going forward. It simply means that you cannot mandate a passport as, a vaccine as a basis for entry. The interesting question is going to be whether or not you can still require people who aren't willing to produce proof of a vaccine to follow heightened protocols such as a mask or social distancing. That's where this issue is going to become interesting and possibly even contentious.
Kim, did you have anything to add to that?
No, I think Ken summed it up.
Great. So another bill that came about March 29th, 2021 was the Senate Bill 72. The COVID liability bill was signed into law. It says that if you, as an association, made an effort to follow local ordinances and guidelines, you may open up according to and not face any liability. So Kim, I'll direct this question to you since you're on FirstService Residential's coronavirus task force. I know you've taken the lead on keeping the team informed and staying up to date with statewide ordinances. Can you summarize what the COVID liability bill means for us? Also, what are the benefits of having this bill in place now at this time?
Sure, Chris. For associations that have followed local, state, and CDC guidelines concerning social distancing, disinfection, sanitation, amenity closure, reopening social gatherings, it means that the association cannot be held liable for someone who claims to have been exposed or gotten COVID at the association. Prior to SB 72 being signed into law, the associations could face potentially serious legal and financial exposure, which was compounded by the fact that most insurance policies don't cover infectious diseases. So this could have been, catastrophic in some cases for community associations. The associations that have followed and continue to follow the protocols set forth by local, state, and CDC guidelines concerning social distancing, sanitation, amenity closure, reopening, and social gatherings will be protected from liability concerning COVID-19. And I think Ken has some thoughts on that as well.
Well, yeah, I do. What is required, and I alluded to it earlier, is that the association make what is called a good faith effort. And the emergency powers statute, even before it was amended, contemplated that decisions would be made based upon consultation with appropriate experts. The association has been protected by what's called the business judgment rule, which means that as long as you make decisions in a reasonable manner, the board is protected to a certain extent from having a court second guess its business decisions. But COVID created a whole new issue, a whole new frontier for legal issues and for operational issues that management companies have had to address. I have been advising my clients since day one that you have to find a way to strike a balance. And you strike a balance by consulting the medical professionals that are available to you even within your community, by consulting CDC guidelines, by consulting Department of Health guidelines, by considering the demographic in your building. You have a predominantly elderly population. Do you have a lot of people with underlying health conditions? What is your building structure? Do you have a service elevator for people making deliveries and otherwise coming to work in the building, or does everybody use the same elevator? What is your ability to afford heightened levels of monitoring for people coming to and from the building, or heightened levels of staff to provide the appropriate cleaning services? So I think all of these things factor in and have, since the inception of this pandemic, factored in to what constitutes a good faith effort. And I would add that the creation of a liability shield, even though it's not absolute, it is a liability shield. I don't think it is a reason for us to forget our humanity. And that is that we have people living and working in all of these buildings. And even if we are safe from liability, that doesn't mean that we should be cavalier about providing appropriate safety protocols.
Absolutely. Governor DeSantis also issued the Executive Order 21-65. This is categorically remitting all fines upon individuals and businesses alike related to COVID-19 restrictions. So Kim, what are some of the financial implications of this for the community associations?
So Chris, for the community associations that may have had fines imposed between March of 2020 and March 10th of 2021 related to local government restrictions and or fines for individuals and businesses that are now covered under the Clemency, meaning they don't have to be paid. For an association that may have been fined by a local municipality, the fines are now waived. For individuals that may have been fined, those fines are also now waived, which means that the association can't collect the fines. And the fines need to be waived on their ledger if they were already collected, if they were imposed during the time period noted above. Most associations were using violations and fines really as an enforcement mechanism to gain compliance during COVID-19 for mask wearing, social distancing, and amenity usage. Those are all pretty good examples. Can some associations have asked if this part of the order also applies to fines issued or accruing in conjunction with municipal compliance orders? What are your thoughts on this?
Well, I don't think the associations are going to be subject to fines for the same reasons that businesses and individuals are not. I think the question that we're going to get to is, can the association still levy fines, which is one of the important enforcement mechanisms available to an association, without having to hire lawyers to file lawsuits? And it is my opinion that the association can still enforce its restrictions, even its COVID restrictions, by invoking its available remedies, one of which is the right to impose a fine. I would rather err on the side of continuing to adopt and enforce COVID restrictions than allow violations of those restrictions to go without consequence, because then the restrictions become meaningless.
Great point.
Yeah. So just talking about April 29th, 2021, the Surgeon General, Dr. Scott Rivkees, he issued a public health advisory, one stating that continuing COVID-19 restrictions on individuals, including long-term use of face coverings and withdraw from social and recreational gatherings, pose a risk of adverse and unintended consequences. Two, further expanding vaccine eligibility, and three, advising government offices to resume in-person operations and services. So Kim, what does this mean for day-to-day operations of our communities, and what should they immediately be prepared for?
So Chris, thank you for that. For FirstService Residential, we've managed our day-to-day operations throughout the pandemic, consistent with the CDC state and local guidelines. What's happened now with the governor's recent orders, it's created a lot of confusion for residents, guests, and even the different municipalities, as they have provided different guidance related to the governor's order. For example, Miami-Dade County is still recommending that people follow the CDC guidelines, where Broward simply defers to the governor's order. Businesses still have the right to ask customers, residents, clients to wear masks. However, we've seen a lot of people refuse masks and social distancing, which is creating conflict in our associations just between neighbors. So we strongly recommend, prior to making any changes, that the associations consult with their counsel. Many people have been isolated, they've had loss, they've had diminished income, children attending virtual schools. So the unintended consequences are definitely there. But I think society as a whole, who has a segment of people that want everything open now, and others are looking to take a more measured approach following the CDC guidelines about reopening. And this isn't really different among community associations.
And Ken, did you have anything that you wanted to add to that as well?
Well, briefly, there is a certain tension between the policies articulated in the Surgeon General's advisory and the realities on the ground. Everyone feels COVID fatigue, everyone. But by the same token, Broward, up until just today or yesterday, has been classified as extremely high risk. I think today it was reduced to very high risk. So there are still hot spots where we still need to be safe. And even though there are psychological consequences to the wearing of the mask and the withdrawal from social interaction, there are even greater consequences to not taking appropriate precautions to protect people from contracting the virus. Obviously, expanding eligibility for vaccines is a wonderful thing, but you combine that with the reality that we can't require a vaccine passport for you to come into our business or into our building. So the expanding eligibility for vaccines still requires everybody to make an individual choice to get vaccinated or not. And as far as encouraging government offices to resume in-person interaction, there's no people more on the front lines in the communities than the management company people there. And you still have to provide service to your people, to your customers, to the owners, to the board members. And obviously doing that in person is far more advantageous than doing it remotely, but it still has to be done safely. So is it still reasonable for an office to just be closed to in-person visits? Maybe not. Can you still require social distancing and the wearing of masks for people who want to come into the office? I don't think that's unreasonable.
Great, it's a good point. So I'm going to quote Governor DeSantis here in what he recently said when enacting this. Whereas in light of the recently enacted reforms, the widespread vaccination of Florida residents, and the sufficient supply of vaccines for all eligible Florida residents, I find that it is necessary for the state of Florida to enhance its rapid and orderly restoration and recovery from the COVID-19 emergency by preempting and suspending all remaining local emergency restrictions on individuals and businesses, and return day-to-day life back to normal everywhere in the state. So I'd love to get your opinion and share your vision on what return to normalcy means to you. So Kim, if you wanted to kick us off.
Sure, Chris. I'd say that for community associations, we're still likely to see a more measured individual community approach leading up to the expiration of the state of emergency. Given the demographics in most of our communities, I think our communities have embraced virtual meetings, and that trend will continue in conjunction with the in-person meetings as those begin to ramp up. The virtual meetings have really just created more of a sense of community, and you've gotten more involvement and participation among the residents. Aside from that, we're seeing some level of board burnout, which is leading to board leadership changes within the associations. That coupled with the employment crisis in South Florida due to the extended unemployment benefits and governmental subsidies. We have dealing with rising cost of childcare, gasoline, groceries, and just general inflation as we move to resume to the normal operations. With cost of wages rising to meet the demands of the market, rising insurance costs, not just across Florida, but other markets as well, as a result of the global events, the associations really need to start planning early for 2022. And aside from that, I really think, at FirstService, early during the pandemic, we developed a code of conduct, which talks about civility and decency. And I think that's one thing that really needs to continue. And I think Ken had some great points when we were having a conversation earlier that he might want to share.
Well, those are very important operational business points, but it's interesting, Chris, your prior question was that the Surgeon General said that the long-term use of face coverings and withdrawal from social and recreational gatherings pose a risk of adverse and unintended consequences. I think those of us who are dealing with community associations know what those consequences are. It's anger, it's frustration, it's a lack of civility. And it's become worse as the pandemic has gone on and on and on. I think normal is never going to be what it was 14 months ago. I think normal, though, one of the good things to come out of this is that there's going to be an increased use of technology to facilitate more unit owner participation at meetings. I think people have become accustomed to the format that we're using right now, which is a Zoom call where we're all together, but we're not together. I think anything that facilitates unit owner attendance and participation in the discussion and allows unit owners new ways to vote, whether it's electronic voting or you adopt a resolution to allow owners to voice vote when they're on a Zoom call, I think those are good things, because one of the most difficult and frustrating things in the community association has over the years been getting people to participate. Anything that we can use that is technological, that is a convenient way for an owner to be there and participate, is a good thing. But I want to come back to my other point, which I think has to be part of the return to normalcy, which is a return to civility. We live in a very divisive era. It exists nationwide, it exists countywide, it exists citywide, and it has made its way into our communities. And anything that can be done to bring the community back together, to increase the level of civility, to improve the quality and caliber of communications and interaction between the owners, means that you will not be dragging your manager and your lawyers into disputes over behavior. The best way to devote the resources at your disposal, particularly management and counsel, is to pursue the constructive needs of the association, to update your documents, to update your rules, to help you with major contracts, to help you with operational protocols that make you more efficient or more cost efficient. Having to regulate behavior it's just not a constructive use of your resources, but in this time of incivility, it has become almost unavoidable. So anything that can be done, including adopting rules that prohibit levels of behavior that is uncivil toward other residents, toward staff, at board meetings, at committee meetings, at membership meetings, at the pool, some sort of a code of conduct for people to follow and for there to be consequences for violations, to me is important, because some people will automatically resume a level of civility. Some people may have to be dragged kicking and screaming.
It's a great point, and I appreciate you bringing it up. So those were all the questions that we had specifically related to the new executive orders by Governor DeSantis. But I did just have one other question now that we have Ken, an expert on here that can answer this for us. The Omnibus legislation. So this is Senate Bill 630. I want to know how this might impact community associations. So I know it's a 100-page document. So Ken, maybe if you can summarize it for us, the key points for community associations.
Let me give you my 2-minute drill here. For those of you that have seen subrogation claims from unit owner property insurance carriers, those may be going by the wayside, and I think that's a good thing. For those of you that have questioned whether the 8-year term limit applies to people who've served in the past, this legislation makes clear that it only applies effective from July 1st, 2018 forward. For those of you that screen sales, leases, and other transfers, transfer fees, which have been set at $100, have finally been increased to $150 and are subject to a 5-year increase based upon the Consumer Price Index. Not only have you been required for the past few years to allow electronic charging stations in an owner's parking space, you now have to allow a natural gas station. So good luck with that, because I don't know about having a natural gas station next to an electronic charging station, but there are going to have to be some serious code requirements. More applicable to this subject is the clarification of the emergency powers provisions in the condo co-op and HOA statutes to make it clear that they apply to this sort of an environment. Obviously, those provisions were drafted and enacted in response to what we face most frequently in Florida, which is hurricanes. But now that we've been through a pandemic, we realize that emergency powers would also be applicable there to say that maybe we shouldn't have the gym wide open. Maybe the gym shouldn't be open at all. Maybe the rec room shouldn't be open. So the emergency powers now apply to this sort of a situation, and they also are now accounting for, during an emergency, the use of electronic meetings and other means of allowing participation remotely. Because a lot of communities have wrestled with, do we have to even allow an in-person site for our annual meeting? And a lot of people didn't. Now, as long as we're in a state of emergency, you can do that. So a lot of this will unfold as the pandemic continues, or more importantly, and hopefully eases. But there are certain aspects of this bill that you should be aware of as managers and as board members, because they will affect operations going forward.
Great. Kim, was there anything you wanted to add or any questions that you had for Ken about that?
Yeah, the only question that I had is it relates to the subrogation change on the insurance, Ken, does that really create almost a no-fault insurance provision?
Well, I don't know that it creates a no fault, because subrogation is basically one insurance carrier saying that I paid for my insured's damage, but you, third party, caused it. So I'm making a claim against you for me having had to pay this claim. In other words, I'm going to stand in the shoes of the person I'm insuring because you damaged them and thereby damaged me. Does it mean that it's no fault insurance? No, but it doesn't mean that the carriers may be taking a more discerning look at claims or maybe modifying their policies to reduce the available coverage in the event of third-party negligence. Maybe, because it's going to cost them money. Up until now, the subrogation claims have resulted in some revenue coming back to carriers who paid for property damage. They're no longer going to have that revenue if this bill actually manifests itself in condo policies not providing for rights of subrogation. So stay tuned.
That's great. And again, thank you for reading the 100-page document so that I did not have to. So
it's better than a sleeping pill.
So those are all the questions that we have today to cover. Thank you, Kim and Ken, for such a great discussion and sharing your expertise with all of us. I know that our board members of our communities that we manage are very appreciative that we've kept up to date with the changing ordinances and health advisories to provide guidance on running their condos and community associations. So things like the coronavirus task force, Kim, that you led, that was fantastic, allowed us to really stay informed. So just in closing, we'd like to remind all of the listeners today that FirstService Residential has recommended to our boards that they do not make any changes in operating procedures and measures without alignment with fellow board members and approval of the association attorney. Really important point to make there. FirstService Residential will continue to rely upon the guidance of Centers for Disease and Control and our current operating protocols and our health and safety commitments will remain in place. As a part of our promise to deliver exceptional service, FirstService Residential will continue to advocate for associations before policymakers and regulators on behalf of our customers, residents, and partners. So thank you again, everyone, for joining us today. We hope you enjoyed, and we will see you again soon.
And thank you for inviting me to join you.
Thank you, Chris.
My
Thank you,
pleasure.
Ken, for joining us.
My pleasure.